May I please, your lordship?
Yes.
I beg to mention item number 14 from daily list and item number 22 and 24 from supplementary list. My senior Ethar Chaudhary is out of station. Kindly matter may be fixed on 6th of November.
কোনকেইটা হেৰি দিয়া বুলি ক'লে? One and 15. 14 apparently you brought by order.
Admission, your lordship.
It's by order. Someone mentioned it to have it on board.
Yes, your lordship, but he could not reach Guwahati because due to non-confirmation of ticket, my senior is Sri Bhumi now.
Item number 14 on Likibo, although this matter had been listed at the request of the learned counsel for the petitioner, it has been submitted today on his behalf that he could not arrive at Guwahati. And therefore the matter will be listed after
6th of November.
7th of November.
And item 22 and 24 from supplementary list also.
Prayer is allowed. Is this matter on 7th?
Same date.
Right, to number 23 and 24. Or 22 and 24.
4 yes, your lordship.
Same order.
Your
So
lordship.
separately.
Obvious, your lordship.
This yes.
Seven. Obvious, your lordship.
Yes,
Please, Lordship, like to mention item 21,
21.
instructions from my client to withdraw the petition as the matters become infructuous.
We got a request to them only. A VC request was there.
Unfortunately, my senior could not join
Okay.
because of network issues.
Okay. Item 21 applicable. The Mr.
S. Barua on behalf of RJ Das.
Submitted that. He is under instructions not to press the writ petition in the present form as it has become infructuous. Learned counsel for the respondents do not object to the same.
Respondent number 1 and 2.
So and so appears for the respondent number 1 and 2. In the prayer meet, this writ petition is closed as infructuous.
Please, your lordship.
Yes,
Item 15.
15.
15.
Yes,
The respondent counsel is out of station. I've taken consent from the other side. They will come up after 15.
I see at least one of the counsels for the respondent.
Yes, I am for the respondent.
A prayer has been made by the, on behalf of the learned standing counsel IOC by moving an adjournment slip with the consent of the learned counsel for the petitioner. The matter may not be taken up today. Accordingly, list the matter after a week on a date to be fixed by the registrar.
Or should the interim order may be continued?
The interim order passed earlier shall continue. What about item number 1?
In respect to item number 20, Lord, I would like to
20.
mention item number 20. Lord.
Hmm.
This matter, Lord, we have taken the concept from the other side as well. Some instructions are available, Lord, to be in the.
You are appearing in item
Yes.
20. No objection. A request has been made on behalf of the counsel for the respondents with the consent of the counsel for the petitioner for an adjournment in the matter. Stop. List this matter after 3 weeks on a date to be fixed by the registrar. It's
My lord, the council is on lax in court number 6, my. Actually, item 1.
Because for the IOC, they have moved an application. With your consent, I think. Yes, sir.
I'm appearing for respondent number 1.
Respondent number
1. Union.
1. They have made a request for adjournment by moving a slip.
Yes, lordship, but
Should we grant it?
yes, lordship, I have done. There is a interim order. Interim may be continue, your lordship.
A prayer has been made on behalf of the council for the IOC that the matter may not be taken up today. Would stop the consent of the learned counsel for the petitioner and the learned counsel appearing for the other respondents.
Not one, only
The other the respondent number 1 has also been obtained. Accordingly, list this matter after a week on a date to be fixed by the registry. Interim order passed earlier shall continue.
Deeply apply, Lordship.
Yes. Yes, sir.
May I please Lord.
Hmm.
Instruction order
Yes, BTC.
A non-payment of bill, my lord. Admitted bill, my lord.
Huh?
Admitted bill, my lord.
The line of commissary lodge.
Dispose of. You are not disputing the claim. We will pass orders.
Lodge.
Disposing it off on the lines of commissary, that if whatever is the admitted amount, you pay him.
Lodge.
Whatever remains unadmitted,
Lodge.
he would be at liberty to accept.
Lodge.
Okay.
Deeply obliged, lodge.
Dispose করবো। Yes.
Covered matter
By
by WPC number 2068 of 21, Lord.
Mr. Chaudhary, you agree?
Yes,
It's covered. You are Mr.
P. Sharma.
Heard Mr. P. Sharma, learned counsel appearing for the petitioner. Also heard Mr. B. Chaudhary, learned standing counsel, Finance and Taxation Department, which stop. It is the submission of both the counsels at the bar that the subject matter of this writ petition is covered by the judgment and order passed in WPC number 2068 of 2021 and other connected matters on 29/4/2025. Full stop. We have gone through the order dated 29/4/2025 and in the observations of the court in para 99 and para 100 and 101 covers the cause. The petitioner's full stop. Accordingly, this writ petition is disposed of in terms of the order dated 29/4/2005, passed in WPC 2066 of 2021 and other connected writ petitions. তাতে সেই তলত এটা লাইন এড কৰিব লাগিব Mr. Chaudhary, the directions given therein to give notices in the other order
Lordship,
that we will incorporate.
yes, Lordship, otherwise the challenge to the scheme
that has been set aside.
rejected. And
Whatever
Yes.
representations they have to make and whatever consideration you have to give, that part will incorporate in the order.
Yes.
Yes. Yes, sir.
The item number 4 and 5.
Mm.
In this case, pleadings are complete here,
Mm.
Lordship. So matter will fix for hearing by fixing any date, Your Lord.
What is the matter about?
Regarding ex gratia grants of the petitioner, Your Lordship.
So why do we need a hearing on that? Why are you resisting his claim for ex gratia?
Because his claim is prior to the basis of his claim is notification dated 15/11/2014.
Mm.
But his incident took place prior to that, my lord.
But I
That is why he is not covered, my
But
lord.
I think there is a judgment which says that if you don't pay till the new notification comes, then the terms of the new notification will govern it. Is there some judgment like
My
that?
lord.
Yes.
That is our stand official stand, my lord.
Ah.
In both the cases, that is our official stand.
We could have just brought the judgment and we could have decided it. Okay. But Mr. R.M. Das, R.M. Chaudhary,
My lord.
then a counsel appearing for the petitioner. Also at so and so appearing for the respondents, full stop. The pleadings, now it is submitted that the pleadings in the matter is complete and the matter can be taken up for disposal. Full
Right.
stop. Matter relates to payment of ex gratia on the death of the who expired. Petitioners who?
Further.
expiry of the father of the petitioner. This matter in the month of December 2025 in the hearing column on a date to be fixed by the registrar. For disposal.
Master.
Ahmed, please, Your Lordship.
Yes, sir.
Your Lordship, the pleadings are completed in this matter. Only thing is that we have filed an affidavit in reply
Hmm.
to the affidavit in opposition filed by respondent number 3. That I've been informed is not on file,
When did you file it, sir?
on 31st, Friday, last Friday.
Okay.
Otherwise, the pleadings are complete.
The
Respondents
affidavit in
also-
reply would be required perhaps to rebut
Yes.
the affidavit in opposition. We'll have it on record and fix it. Who is appearing for the
B.
respondent?
Gogoi. It's a health and medical.
Third, Mr. D. Senapati, learned counsel for the petitioner. You are appearing for the health?
Lordship, yes, Lordship.
There is an affidavit in reply filed
Yes,
by.
yes, we have
It is
received.
awaited on record.
Lordship.
So we'll fix it when
Can it be on 26th of November?
26th. It's. It has been submitted, Mr. Swenso appears for the Department of Health and Family Welfare. Stop.
Lordship may record Birugo's name in
Mr. Bigogo appears with. It has been submitted by Mr. Senapati that the affidavit in reply filed on the 31st of October 2025 is not on record. Instead registry to verify the filing and place the same on record. Full stop. The matter be listed on the 26th of November 2025 for where on which date an attempt will be made to dispose the matter.
Not so.
Lordship.
Yes. Reply is on record.
I have raised objection regarding maintainability of the petition. Actually, they have assailed an order of the RERA.
Ah,
They filed an appeal before the appellate tribunal that they have withdrawn.
Hmm.
Now, by way of writ petition, they have assailed it. So under the provisions of the act, it's impermissible.
why?
All statutory appeal is given. There is a remedy.
So, is it your argument that this court would not interfere in any matter where there is a statutory appeal provided for? Article
Because,
226, I think,
Uh,
we'll go a little bit further if she can show a violation of a right or maybe a.
because even otherwise on merit.
Merit,
there
she
is
has
no-
to start, then we can hear you.
That's it.
Lordship,
You-
my lord,
Yes.
what happened, my lord, the petitioner before your lordship,
Mm.
her husband took up a project
Mm.
under the name of Naina Apartments.
Hmm.
So while the project was on, he fell sick. He was undergoing some kidney treatment.
Mm.
And then when he realized that it is not possible on his part to complete the project, he entered into a registered agreement with Madhav Sharma.
Hmm.
Before his death. He died on 18 to 2020.
Okay.
Before his death, that is on 19/10/19, he entered into an agreement with Madhav Sharma.
Hmm.
That was registered agreement. By virtue of that registered agreement, entire project was transferred to Madhav Sharma.
Hmm.
And there was a clause that all those purchasers who have already made complete payment, they would be handed over possession, and those who have not made complete payments. So Madhav Sharma is at liberty to take further payments from them.
Okay.
So my liability ends there, like the petitioner's husband. Now what happened, one complaint was registered with RERA
Hmm.
by the private respondent number 2. Now, there they have said that I am liable to hand over possession of that building to them.
You are Gargi associate.
Gargi, so
Okay.
I'm the present petitioner is the wife
Hmm.
of the builder. Now, their claim is that it was my duty to hand over the project because I had taken all the money from them. And since I have not handed over the project, they have gone to RERA. Now, the RERA is also saying that this agreement by virtue of which this project was transferred is also not legal because by then this act had come. So after passing this RERA Act had come into force, this agreement was not valid because it has to be registered. Now the fact remains, my lord, if that agreement is invalid, my lord, then the project should be reverted to me. I am not in the possession of the project. The entire project has been transferred to Madhav Sharma. This person who is the complainant, he knows very well that the project is transferred to Madhav Sharma. Madhav Sharma is not a party before RERA. Conveniently, at the behest of Madhav Sharma, this application was filed in before RERA, alleging that I should hand over the possession.
How do we come to that conclusion?
My lord, and then my lord,
You are saying the person behind the complaint is Madhav Sharma who entered into an agreement with your husband.
yes,
How do we come to that conclusion in a writ petition?
no, that is there on record, my lord.
That
Now,
is there on
what,
record.
yes, my lord, that agreement is there.
Okay.
Agreement is there.
Hmm.
Now, my lord, what had happened that now RERA has passed an order against me, saying that I'm not entitled to any relief. Now, that was put to challenge
No,
in appeal. In nutshell, my lord, I'm giving
RERA gave relief to them.
them.
Ah.
So I went for appeal. Now,
Hmm.
appeal, there is a provision that you should make a deposit, pre-deposit of 60%, I think. So now she is bankrupt. Her all properties have been, my lord, attached by the bank in other proceedings. Now she is not in possession of the project. Also, she cannot anyway make the pre-deposit. And then RERA did not take into account the fact that the project was transferred to somebody else. Therefore, my lord, for waiver of pre-deposit, I am before your lordship.
Can we go for waiver of pre-deposit, statutory pre-deposit?
Statutory pre-deposit.
Can we do
Under
that?
the facts and circumstances that
In somewhere recently the Supreme Court has held that this kind of
it is in
interferes in the
surface matters.
whichever matters, we interfere in the statutory deposit, it would not be correct under Article 226. We should not interfere in those
My lord.
matters.
My lord, be that as it may, if even if we take it for the time being, that my appeal is also gone in that case. Maybe for want of pre-deposit also, my appeal is gone.
Okay.
So on merit, my lord, what I submit, that the order passed by the RERA is cannot be executed, my lord, because I am not in possession. How can I hand over the flats to them?
See, that has to be a stand taken for a review under the RERA or something that we cannot decide
that
here.
was also done.
When you are depending upon an agreement, which agreement has been held to be not in consonance with law because of the oncoming of the RERA,
RERA.
then either you have to get the project back from Madhav Sharma.
That's it, my lord. So
There, I
that's-
don't think this court can help you.
My lord, that
You
is.
can pray for some time from RERA to take up appropriate proceedings, saying that since the agreement is illegal, Madhav Sharma out, I mean, you take your responsibilities, finish the project, give them whatever they need to be done.
My lord, all others have taken possession, my lord.
Only one person remains.
My lord, this person is.
Even in that
He
case,
has to take up this matter with Madhav Sharma, not
No.
with me.
he will not, because he is not a party to that agreement between you and Madhav Sharma, perhaps.
No, he was not.
He was not. Now, Madhav Sharma and your agreement is not tenable in law, if we can say so, for the RERA, unless you can show that RERA was wrong in coming to that conclusion. Then your relief lies against Madhav Sharma. Whatever happened under that agreement,
My lord.
that has to be nullified. Everything has to come back to you. Whatever Madhav Sharma did on a belief that the agreement is a legal agreement,
My lord.
you will get. The rest comes back to you and you execute whatever agreement
My
you
lord,
have.
practically that is not possible as on date because all these that's taken already.
So what has been done is done. Those people, they did not know about the illegality of the agreement, so their rights should not be perhaps touched upon by the civil court. So far as he is concerned, you have to use the agreement, this order. How can the report help you here?
Can I come back on Friday, my lord?
Yes. Have your instructions.
My lord.
It is only because to bring a quietus, if you can agree to follow the appropriate course in law, perhaps this will be, but otherwise we have to say we cannot interfere. That will not be to anybody's benefit. Yes.
Lordship, I am a simple person, Your Lordship. I have retired as a veterinary doctor.
Ha,
I have disposed of my property at Jorhat
ha,
and booked this flat. I
yes.
paid an advance payment of 34 lakhs.
True.
Now, I sought a return of the money.
Hmm,
And I'm not interested in the flat anymore
hmm,
because there is delay.
Hmm.
And I approached the RERA praying for that.
hmm.
The RERA allowed my application. And this agreement that she has entered with Madhav Sharma.
What
that is-
you are now trying to submit,
Yes,
this perhaps we should not say, but otherwise you will be flogging a dead horse. The lady is in no position to give you the money because
no, she is in a position. There is,
Go
as
for an
far
executive
as I
file.
know,
RERA has given you an order. There is no stay. Is there a stay operating? No stay operating. Why don't you go for an execution to?
I have been pressing before the DC office
Ah,
for Baki's
that
Act.
is not a subject matter of this writ.
But because of this writ
This
petition,
is
they-
not a subject matter of this rate. Come up with an IA, do something, do something.
But-
Like we have told her, we will not be able to interfere
yes,
on the prayers made.
prayers.
We will not be able to interfere on prayers not made.
Not-
You have
But,
not made that
uh,
prayer.
Lordship, if this is gone, my road will be clear.
It's on Friday. She wants to have instructions.
Can it be on Thursday? Lordship?
Huh?
Thursday, Lordship, Friday.
Thursday, 6th.
Thursday, then it used to somewhere around 25th or 27th. We'll fix it on 25th, ma'am. You have your
25th.
instructions, madam. Pardon, Miss P. Chakraborty. And a council paying for the petitioners. Petitioner also heard Mr. Swenson and a council paying for the respondent number 2. Anybody paying for the others? How many
One,
respondents?
they have filed affidavit or they have not agreed.
Anybody appears for the RERA
Lordship, they have filed an affidavit, but today they have not agreed.
through HK Sharma?
HK Sharma.
You put it just like that. Mr. Swenson appears for the respondent number 2 after sending hearing in the matter. Ms. P. Chakraborty, Learned Counsel paying for the petitioner has sought for some time to have instructions on the queries raised by this court. Stop. Accordingly, list this matter again on 25th,
Can it be on 26th, 27th, madam?
27th of November 2025 for further hearing.
Much.
My presence. As per the order dated 24/9/25, I filed my additional affidavit in the record.
We also file an affidavit additional
Hmm.
on 28/10/2025.
We have both of them.
Malat, you also kind of peruse the is Malat 107 of my additional affidavit. Malat.
But
They were supposed to give you a certificate
Malat,
of handing over and taking over.
Malat, after interference of this honorable court, they have provided us,
Ah.
Malat, but one aspect of the matter, the item number 6, Malat, which my lord, at page 5, Malat, they try to deny it.
Page
In
5
a-
of what?
Page, I mean, Malat, paragraph 5, Malat,
Of
page 107, Malat,
Page 107.
Malat.
their additional affidavit here is filed, but the petitioner is not provided.
I don't know, without providing them, the affidavit must probably put not be filed, Malat.
Let me check the notice because I have not received the affidavit.
Additional affidavit by Uday Gogoi.
Malat.
Yes, that copy is not served to us.
That copy is not served.
Yes.
Malat, why I am pointing out, Malat,
It
My lord,
is.
they try to
it is-
deny it, my lord, saying that,
Goswami,
but one in
Mr.
one affidavit.
Goswami, in fact, that copy has not been served. It has been served on the GA Assam.
Well, can it be, there is urgency, can it be in a specific date, my lord, this.
What were you saying? Can you show us again? Para 5.
However, I want to show that earlier in affidavit 31/7/2024,
Uh,
Annexa A2, their statement is that, yes, it was done. That means that document was executed. Now they are trying to project that. However, Penalty's advocate of the said period did not submit the document as well as any document prepared in this regard. In fact, they file an additional affidavit in this regard pursuant to this honorable court's order dated 22/9/2025.
Hmm.
In their affidavit also, page 109,
Hmm.
the last part of the
Start from,
first paragraph, my lord,
start from page 1013 para.
they
6.
try to say same thing. That above mentioned panel advocate, the name of the panel advocate is written as Ruby Devi 1. What happened? Why I am pointing out?
Which paragraph are you reading?
My lord, paragraph, my lord, 6,
Page 10,
109, my lord.
113.
Yes.
My lord, there, in the fifth, my lord, line, a draft lease agreement was prepared by Ruby Devi advocate.
Hmm.
Panelist number 1. My lord, which was approved by the respondent authority for execution, but surprisingly said lease agreement was neither executed nor submitted. They try to play with the code, my lord. In one affidavit, they says, yes, it was executed. Now they are saying that the penalist advocate has not provided us. That is why it could not be executed. In fact, my lord, they last that paragraph, the last from third line, they are saying that the above mentioned penalist advocate dated 4/11/2019, and therefore no such lease agreement was executed during this period, my lord. You listen, minded, my lord. My client telephonically contract that lady advocate, my lord. What she is provided that that the lease was executed before notary, and subsequent to the lease, my lord, person was that, namely Sanjeev Borua. They said was for 35 years it was given lease to that person, and to that effect 4,10,000 was received by the authority, and the check number is also there, my lord. That is, of course, after I received the copy
No,
of the
your
affidavit,
prayers-
additional affidavit on the 30th.
Your prayers in the writ petition are that they should be directed to the furnish the information and initiate appropriate legal action.
They mislead
regarding
us,
the-
my lord.
Regarding the information.
My lord, they mislead
Now,
the information.
your stand is that on one affidavit, they say that yes, an agreement was
Agreement was
executed,
executed.
and on the other they say we don't have a copy of the agreement because the council never gave it to
My
us,
lord,
and
my
therefore
lord.
it was not executed.
My lord.
These are the two stands. Now, if their stand is that no, it has not been executed and we do not have a copy, we cannot go into the office to bring that copy.
My lord, that is why I want to brought to the knowledge of the court the amount which was received by the JDA against one Sanjeev Borua. That is a case memo I received from them, my lord.
Hmm.
As directed by the court, they provided us.
The issue
It will
that
be placed before your lordships
Mr.
to
Goswami,
clarify this stand. The SAD was given for 35 years
Mr.
less.
that is not an issue before this court. Whether
My
the
lord,
shade
they
was given
mislead
to
the
what-
courts, my lord. That
that
is,
is what
I
we will
want to
try to
bring it
find
to
out.
my lord, knowledge of the court. That is why,
Yes. Now, if you give him a copy,
my lord,
since only the government advocate has a copy
My
as
lord,
per
my
the
lord.
notices,
my lord.
there is only a seal of the government advocate and there is a signature.
My lord, I'll provide
No
him the
other-
copy
no
as
other.
well as I'll bring it to
Give them a
the
copy.
court's knowledge about this
Give them a
development.
copy, let him have the scope to answer that.
My lord.
When Mr. Chetri,
Already
going
said.
here and there is not going to help anybody. Perhaps if you want to say, yes, execution of a deed, but we don't have a copy, be straight with it. No execution, be straight with it.
Specifically said in our
Jumping here, and there,
Parasite.
then
Because-
where come the first information is there that yes, it was
lordship
executed.
may come to the page 118.
We read the part where you say that yes, it is executed.
Yeah.
Now you say no,
No.
it is not executed.
Not execute.
So how is it specific?
No, lordship may see
We'll have
the
both
para
the
six. No,
deponents here to explain.
He said
Yes.
Let him bring this.
I am not saying their affidavit.
No.
Affidavit dated
what he may see-
31/7/2024
He
specific.
may see it is done, but I just go to the page one.
White doves. We will have white doves flying here, peace.
Yes.
Let me dictate the order.
Malak.
Yes.
কিন্তু উক্ত প্যানেলিস্ট they said কোনো তথ্য এই খণ্ডত প্ৰস্তুত কৰা নাছিল। So they have the advocate who is given to them, they yes, you do that thing, but he is not submitted agreement.
The question is, did you execute an agreement or not?
At that point of time, we have not.
No agreement was executed by him. What happened to his money?
It is his allegation. Let it come to the clean hand. It is says, yes, this is execution. And one more thing, I just place one judgment on this honorable court, the ordinate base of this court. It is same thing. Next day. please
You
go
want
for-
to argue the matter without a copy of the
No.
affidavit filed by him? I am ready to hear you. Should we start?
No, no. Yes.
Mr. UK Goswami Learned Counsel appearing for the petitioner has submitted that an additional
Sure, true.
affidavit was filed on 28/12/2025. Full stop. The affidavit is available on record. However, Mr. A. Chetri appearing for the respondent number 3, 5, and 6 has submitted that he is not in possession of the copy of the affidavit. Full stop. Mr. Goswami Learned Counsel appearing for the petitioners have agreed to supply a copy of the additional affidavit filed on 28/10/2025 to Mr. Chetri. Full stop. List this matter again in the week commencing 24th of November 2025 for further consideration.
A specific date for that.
It's difficult for everything. Let that affidavit be with him.
Well-
We'll hear it, we'll do what.
Problems.
I plead your
Yes.
lordship. Lordship, in this writ petition, we are challenging the ombudsman order dated 6/12/2022.
Ah.
Lordship, may kindly come to page 25.
Hmm.
Lordship, the next page is the observation. Lordship, may I read?
Hmm.
During the course of the hearing, the complainant stated that the insured, her husband, had taken elite advantage policy of the respondent insurer commencing on 25/2/2021 with sum insured of rupees 2,14,462. The insured expired on 29/4/2021 due to cardiac arrest. And as mentioned in the hospital death summary, the complainant stated that the deceased insured was 62-year-old and his medical examination was conducted by RI, respondent insurer, prior to the coverage where all parameters were found to be normal. She further confirmed that the deceased insured was not having any pre-existing disease and the death was due to sudden development. They are in the receipt of the repudiation letter dated 30/4/2022 from the respondent insurer on grounds of non-disclosure of pre-existing disease. She denied the same and appealed for the payment of her genuine claim. The representative of the respondent insurer stated that the deceased insured was suffering from pre-existing disease as per the submitted medical documents which pertain to prior to issuance of the policy, and these were not declared in the proposal form. This is our case, Lordship. Lordship, in the proposal forum, they have not declared that he already had the hypertension and diabetes and which was the cause of the death.
Next para, your lordship.
Lordship,
Next para.
Lordship, I'll continue. That constituted violation of utmost good faith clause and hence the repudiation is in order. This forum took note of the medical reports of the deceased insured as submitted by the respondent insurer for 2006, 2007, 2019, and also the pre-acceptance medical examination report. In none of these reports, there is a evidence of such pre-existing disease which warrants any disclosure on the part of the insured. Hence, the repudiation of the claim relying upon these documents only does not appear to be in order. The claim merits settlement. Lordship, this forum has gone through the submitted documents and submissions made by the contesting parties. The respondent insurer is directed to pay that claim by payment of death benefit of 2,14,462 to the complainant. Lordship, we are challenging this order. Lordship,
I would like to take you to the proposal forum, Lordship, where the petitioner has not disclosed his pre-existing disease,
we-
which is it? Lordship,
Are we in appeal? We are not sitting in appeal. Show us the procedural law
Lordship,
and tell us what happened to this order. Is expected, is
Lordship, we
accepted.
have filed a review petition.
Yes, and it
And-
was converted to expected.
Yes, Lordship.
So the expectation goes.
Lordship, I have to do the hearing on merits. Lordship, that is required,
Yes, tell us
otherwise.
then, what is wrong in this order?
Lordship, actually, it was not the proposal forum which was given to the insured. That was, they have not disclosed it, the material fact that he already had pre-existing medical disease.
Hmm.
So that is the main
That is
issue.
ignored by the
Lordship, at page,
ombudsman. Is it ignored by the ombudsman?
Lordship, the only observation is that they have seen,
They should
but they have
put it-
not, but no, Lordship.
Cannot.
I'm not saying that, but they have not taken it into consideration.
And
That
what
is
about
why
this-
before, I am
this
before.
part, This forum
Lordship.
took note of medical reports of the deceased insured.
Lordship, I
as
understand,
submitted
but
by
I
the
would,
respondent insurer for 206, 2007, 19. And
Lordship.
also the pre-acceptance medical examination
Yes.
report. Your report does not
Yes.
say that he has anything like that. How do you expect? him
Lordship,
to
but in
be
the
a
proposal
declaration?
forum, but in the proposal forum,
Ah,
they have not disclosed. And Lordship, I would like to submit few judgments, citations. I would like to give.
where the report has interfered in an order of the ombudsman on these grounds.
Lordship, not the ombudsman,
Who,
but
whose
the
order has
Supreme,
been interfered?
but the Supreme Court has said, Lordship, in 2019 6 SCC 175, 2019 6 SCC page number 175. Lordship, may kindly come to
30.
para 30.
Yes.
Lordship, may I read? It is a standard practice for the insurer to set out in the application a series of specific questions regarding the applicant's health history and other matters relevant to the insurability. The object of the proposal forum is to gather information about a potential client, allowing the insurer to get all information which is material to the insurer to know in order to assess the risk and fix the premium for each potential client.
Yes, we'll read that. Then, does it also refer to any finding where the medical board of the insurer had failed to
Lordship, in
detect
fact,
that? Yes,
Lordship, in fact,
the
in
facts
the
have to match. Facts have to match for us to interfere. If we go
Lordship,
by
one
this.
more judgment I would like to
Yes,
place.
2009.
2009 8 SCC
Page 25.
316, para 25.
Hmm.
The upshot of the entire discussion is that in a contract of insurance, any fact which would influence the mind of a prudent insurer in deciding whether to accept or not accept the risk is a material fact.
Now tell us the documents from where you find you.
Yes, Lordship,
that
I
he
would-
had this condition
Pardon, Lordship?
that he was suffering from a certain condition. Where do we
Yes.
find that?
Lordship, it is in the medical
The
report.
representative of the respondent insurer stated that the deceased insurer was suffering from PED as per submitted medical documents which pertinent to prior to
Pre-existing
issuance.
disease.
Where are those documents?
Yes, Lordship.
Yes.
Lordship, may kindly come to page 64.
64.
Yes, Lordship.
It's,
Lordship, here the blood glucose
Ah.
fasting, it's 220.
hmm,
The normal range is up to 140.
hmm,
Lordship, the next page, blood sugar is 162. Here
Mhm.
is, it is also high.
hmm.
And Lordship, may kindly come to page 82.
82.
This is the medical certificate of death. What is the cause? Lordship, may kindly come to the 2. Here it is type 2 diabetes and hypertension.
Who has written this?
My lord, this is given by the Ayush Sundara super specialty where
On-
the death occurred
On
on 29/4/2021.
And when was the insurance taken?
Insurance was taken in 2021. Date, yeah? 25 February 2021.
So this is of a later date.
Yes, Lordship.
How
When the
was it
death
supposed to
No,
tell
Lordship.
you before that?
No, Lordship. Actually, the thing is, he was already suffering from diabetes,
How do we know
hypertension.
that? That is what I'm asking you, predated.
Yes,
Show me
Lordship. That
something
is
prior to the
2022.
documents submitted by him.
Yes, Lordship,
That
because
he was, in fact, there was some document showing that he was suffering from diabetes.
Lordship at page 64,
Page
Exhibit
64.
H. Lordship,
Page
here,
64, yes.
here, Lordship, blood glucose is 220. It is higher. Lordship, he was also on medication that he have not disclosed in his
Where is
proposal.
it?
Lordship,
Where
the
is your
proposal,
submission regarding that medicine part before the ombudsman?
Lordship, Ombudsman,
He doesn't say so about medicines.
Lordship, that has not been reflected
Then-
in the order.
This is the only point, my lord.
Thing is, a high BP, I was once told in court that if a candidate goes to appear before a medical board, usually the BP is high. Blood sugars levels, layman knowledge can go up for any reason.
Lordship, that
So
is
these
there.
will not be reasons where you can repudiate a claim when your own medical board did not find out these faults. You
Lordship,
had a
but
medical
we-
board. Your medical board could not find it out.
Lordship, that
There
is
must
there.
be some judgment saying that if their medical boards fail, they cannot take the ground. Where is the judgment?
My lord,
No judgment.
only thing, my lord. Not only thing, my lord, blood sugar, my lord,
Huh.
they have stated, my lord, they claim that at the time of, my lord, opening the
Sir,
insurance,
we will not sit down here to measure blood sugar levels, please.
my lord, it is not high, my lord. Normal range, my lord, 70 to 140.
Even I go to a doctor to find out whether it is high or not.
My
How
lord,
can I here give a judicial
Interestingly, my
order?
lord, just before the, my lord, opening the insurance policy,
Huh.
they tested.
So where
Very
is the
normal, my-
judgment? Where is the judgment saying that when their board cannot track up disease, they will not use the disease to repudiate the claim? Where is the judgment?
The judgment I have not, my lord. My lord, in fact, my lord, the point they have raised, my lord, those points, my lord, already, my lord. My lord,
Yes,
on the,
this was.
Lordship, my only submission is that they have not disclosed in the proposal forum, and that is our
A
case.
thing which he did not know, the document submitted by you shows that it was after his admission in the hospital, he came to know about it.
No, no, Lordship.
That certificate is of April. And therefore, he could not have. Your medical board did not have, and therefore, now to show me that I can interfere.
Lordship, the thing is only that in the proposal forum, they have not disclosed.
In 226, I can interfere. Show me that I'll.
Lordship, the
Hmm?
Lordship on merits.
On merits, then on merits, if it goes like this. What is the claim? How much?
2,14,462.
From? When did he
Bharat-
expire?
He expired on 29/4/2021. Just 2 months before
Order is of
insurance was taken.
2022 Ombudsman order.
Yes, Lordship.
No stay. No stay.
No, no, Lordship.
Issue of maintainability of the writ petition is kept open for consideration at the appropriate stage. There is an order. Yes. Yes, you'd like to give some judgments, what?
but, patent I am not having, my lord.
Okay, we are disposing it.
Okay.
That means so and so, when a council is paying for the petition. Also heard Mr. So and so learned fully paying for the petition. This writ petition has been referred under invoking the powers of this court under Article 226 and 227 of the Constitution of India. A seal, the award. What is the award number?
Lordship, page 25.
Wait, what is the number?
Award number IO/GUW/A/L/I/
No number.
2223.
2223 in complaint reference number 1, complaint reference number, you'll find both it, huh? Passed by the Insurance Ombudsman, State of Assam, Meghalaya, Manipur, Mizoram, Arunachal Pradesh, Nagaland, and Tripura. The award was issued on 6th of December 2022. Stop. Next. The husband of the petitioner, is it not? The husband of the petitioner had when did he take it? Had taken an insurance policy with the petitioners herein, and based on the information furnished in the proposal form, he was granted insurance cover under master policy number 502, and so that is at page 25 itself, at the last paragraph, huh? With a cover start on 25/2/2021. Full stop. The company received the claim intimation under the insurance cover on 12/4/2022, since the husband of the respondent had expired on 29/4/2021 due to cardiac arrest, as mentioned in the hospital death summary. Full stop. The respondent had thereafter made a claim, placed a claim before the company within 2 months. Made a claim for the company to pay the insured amount, and the insurer, having conducted an investigation into the cause of death of the life assured, the claim was repudiated. Full stop. The insurance company claimed that it was revealed during the investigation that the, what is DLA in its full form?
Lordship,
What is DLA in its full form? We're using the term DLA. Deceased life assured was a known case of diabetes since 2019 and also suffered left ventricular hypertrophy since 2007 and was under treatment for the same. Full stop. The insurance company therefore claimed that it could repudiate the claim made for the death of the husband of the respondent number 2. The respondent number 2 thereafter approached the insurance ombudsman to the complaint which is already referred to above, and by the award published on 6th day of December 2022, the ombudsman held that the ombudsman took note of the claim of the petitioner, hearing that the representative of the respondent insurer had stated that the deceased insured was suffering from PED as per submitted medical documents which pertain to prior to issuance of the policy, and these were not declared in the proposal form. Full stop. The insurance company therefore had submitted that such suppression constituted violation of utmost good faith clause and hence the repudiation was in order. The ombudsman thereafter, ombudsman thereafter took note of the medical reports of the deceased insured as submitted by the insurer for the years 2006, 2007, and 2019, and also took into note the pre-acceptance medical examination report submitted by the respondent insurer therein and petitioner herein. Full stop. In none of these reports there was evidence of such PED which warranted any disclosure on the part of the insured. Full stop. Hence, it was held by the learned ombudsman that the repudiation of the claim relying upon the documents only did not appear to be in order. Full stop. Accordingly, it was awarded that the respondent insurer was to settle the claim by payment of death benefit of the amount insured to the complainant. Full stop. Assailing such an award, this petition has been filed. Ms. So-and-so, learned counsel appearing for the petitioner, has submitted. Now has referred to, yes, you were referring to which one?
Lordship, 2019
page-
SEC.
No, you were referring to those documents, page
Yes, Lordship, page 36.
36, page 30, no, 36 you did not show us. You
Lordship,
showed
this
us
is the
that other reading doctors,
Lordship, that is at page 44.
Huh?
44.
page 44, has referred to
Lordship, just a second. Page 64, that is the medical report. 64. I'm sorry,
page
Lordship.
64 of the writ petition,
And page 65.
where the blood glucose level of the petitioner has been shown to be more than that of the higher range as on, where is the date?
2/9/2019.
2/9/2019, and
To page
further,
65.
which one, which page?
Page 65, the next page.
Page 65, where the blood sugar level again on 25/11/2019 has been shown to be on the higher side. Now beyond the
Normal range.
normal range. The learned counsel has
Lordship, may
thereafter
kindly reflect this also.
referred to
Lordship, page 68 also here,
Huh?
type 2 diabetes, it is written.
Where?
Page 68.
Let me find that.
Lordship, this is of 2021, 28/4/2021.
When
Here-
was the policy taken?
Lordship, this was policy was taken on 2021, 25/2.
So this diagnosis is again after? Okay. She has referred to the referral summary of the husband of the petitioner, which is available at page 68 to show that on 28/4/2021, the provisional diagnosis of the husband of the petitioner was shown to be fever with metabolic acidosis, with hyperkalemia, with AKI, with type 2 diabetes, with ACC hypertension. She has therefore submitted that in view of the readings available on record, the petitioner, the husband of the respondent had not disclosed the fact that he was suffering from diabetes to the he was suffering from PED in his disclosure form, and therefore the rejection of the claim of the wife of the respondent number 2 was lawful and did not require any interference of the learned ombudsman. Mr. So-and-so, on the other hand, appearing for the respondent, has submitted that the diagnosis of the petitioner, which has been referred to by the diagnosis of the husband of the respondent number 2, which has been referred to by the learned counsel for the petitioner itself, shows that those dates are post the date on which the proposal forms have been filled and submitted, and the period of coverage had started, full stop. Relevant to note here that the period of coverage had started sometime, started on so and so March 2021. Stop. This court has observed that it is not sitting in appeal over and apart of the learned ombudsman. Stop. Since the powers under Article 226 of the 227 of the Constitution of India has been invoked by the are sought to be invoked by the learned counsel for the petitioner, comma. It was and no procedural lapse or perversity has been shown in the observations, recommendations, or final conclusion arrived at by the ombudsman. This court does not find this to be a fit case to interfere. The learned counsel for the petitioner has placed reliance upon the my last paragraph. Learned counsel for the petitioner has relied upon the judgment and order passed in Reliance Life Insurance Company Limited and another, reported in 2019 6 SCC, page 175, more specifically para 30 thereof, to impress upon this court that when the proposal forms suppress information which would be material for the insurer to come to a finding regarding the health status of an insured, of a proposed insured, of a person proposed to be insured, comma, a later claim based on such belief of the insured company could be repudiated on the basis of the materials suppressed. She has also relied upon the judgment passed by the Apex Court in Sankar Sandhu versus New India Assurance Company Limited, reported in 2009 8 SCC 316, where at paragraph 25, the Apex Court have held that in a contract of insurance, any fact which would influence the mind of a prudent insurer in deciding whether to accept or not to accept the risk is a material fact, and any suppression thereof may lead to repudiation of the claim of the person insured. From the records, it is seen that the documents relied upon by the petitioner insurance company itself revealed that the fact of the insured having symptoms of having been diagnosed to be suffering from PED, etc., had come only on his hospitalization in the month of April 2021. And no documents have been shown before this court to indicate that he had any indication of such diseases pre-existing at the time when he filled the proposal form. In any case, such findings would require leading of evidence, which this court will not enter in exercise of its writ jurisdiction. The writ petition, having not the writ petition, since the writ petition has not pointed out any procedural law or perversity in the order, from same stance rejected, the prayer is made in the same stance rejected. So writ petition accordingly is disposed of. Yes.
They may be directed to deposit them, make payment, my lord, within a period.
The ombudsman order is there, you go and get it executed.
Acknowledgement.
Don't make us an execution court. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . Yes,
Lordship, the engaged counsel, Mr. SP Rao, has some difficulty today, so we seek an accommodation for the day.
okay, then on the last occasion also he had some difficulty. On this occasion also he has some difficulty. We fixed it after 4 weeks now. You have to tell us on which date he would not have some difficulty.
Lordship, actually, there's an urgency in the matter. The matter will be taken up on Friday.
Friday it will not be possible. We can go for the last week of November.
Lordship, there's very
What
much
is the matter
urgency in the
about?
matter.
Yes, what is the
Lordship,
matter?
the bank has frozen the accounts of the petitioner
Huh.
because there's a dispute for the property.
Yes, why are you freezing? You are paying for the bank?
Yes, Your Lord.
Why freeze?
Yes, Your Lordship. In this case, the petitioner and the respondent number 3, they are disputing the ownership.
Okay.
That's why we can't.
Why can't you? The bank account is in the name of someone.
Yes.
You have the records of someone.
Yes.
There is no order of the civil court or any other
Yes,
authority.
civil court's order is still there.
Oh,
That's why.
then
Lordship, the order may be disputed because the bank had asked.
where is the civil court order? Kindly show us.
Additional affidavit is filed by the petitioner.
166. Yes, where is the order of the court? Oh, thank you. Why do? The court has to agree, please. Mo bo bilang na pa man ito. Wala ka pa. That is for realization of rent. How does this stop the, where is that order? You, the bank, you have stopped the transactions.
Yes, sir.
Based on what?
Yes, sir.
Based on what?
Based on the complaint filed by the both parties.
Where is that complaint? Can you show us? Not read. A prayer has been made on behalf of Mr. Espira and a council appealing for petitioner that he is in some personal inconvenience today and the matter may be taken up some other day. Full stop. Let this matter be taken up on the no. Prayer is
Lordship, on
allowed.
Friday if possible, Lordship.
Friday we are overburdened already.
Lordship, they have frozen the accounts for over 3 years. Lordship, the
Well, you have been
petitioners are
taken-
facing very much financial difficulty.
We'll try, but we are not sure on certain. This matter again on the 7th of November 2025. At the request of the council. Please come prepared with the annexures. You start studying here.
Allora,
Yes.
similar matters are fixed on 24/11/25, same. 4 matters, just last Saturday.
When?
24/11/25.
Yes, sir.
WPC is 7429.
Otherwise also, Lordship, I think it can be disposed of. Lots.
At a time.
My learned friend is asking.
Because other petitions also there.
You would like a bandwagon with him to argue the yes, every time. Yes, it has been submitted by Mr. P. Sinal and
Yes,
council.
WPC
The
number.
petitioner.
7429.
Yes, WPC number लिख लो. It has been submitted that-
7429/23.
There. Similar matters including WPC number so and so are already fixed. So he therefore makes it clear that this matter will be carried out with those matters. Structure, no? Strategic. So, and that's why. Say Mr. A. Bhattacharya appearing for the respondent number 1 also agrees to the same. For list this matter along with WPC numbers. Yes.
Obliged.
Yes, Mr. Portable.
Lordship, in this case, this matter relates to payment of your Lordship contractual dues, your Lordship. Last occasion, we were directed to file an additional affidavit, your Lordship. And we have brought that order, your Lordship. Now, essentially, case is this, your Lordship. 2 work orders were issued in favor of the petitioner, your Lordship. Your Lordship will get it at page 18 and 19. Your Lordship will find, your Lordship, page 18. One work package number CND D-V oblique E and another one, your lordship, G. Both your lordship were, first your lordship will find that he has completed the work, your lordship. This is 3 years period, your lordship. And your lordship will find, your lordship, there is an certificate of supervision by the authorities, your lordship.
Yes, all the certificates you've given.
Yes, your lordship.
Thereon, yes.
That's there, your lordship. And finally, your lordship, they have in fact paid me, your lordship, 2/3 already paid, your lordship. Last year's, yes, your lordship, that your lordship will get it, that your lordship pays 30, your lordship. This, your lordship, this also has been supervised by the third party monitoring has been done, your lordship. Completion certificate has been issued, your lordship. And thereafter, your lordship, since they have not paid, your lordship, we came before this honorable court. Now, your lordship, they have filed an affidavit in opposition. Now, they say, your lordship, that at page 36(5), your lordship will get para 4. Para 4, that as regards the affirmance made in paragraph 10 of the incident, deponent begs to state that particulars of the work was inspected by Deed and Executive Engineer Division 5 GMC and completion certificate issued by Deed and Executive Engineer of the respective division. Accordingly, file was processed for further necessary action to the higher authority of GMC. However, it is observed by superior authority that no documentary evidence of supervision carried out from the third party monitoring agency was furnished. That, your lordship, it is there, your lordship. In my writ petition, I have annexed that, your lordship.
The
Third party monitoring, your lordship. Page, your lordship will get it at page 30, your lordship.
where do you engineer?
Now, your lordship, I worked, your lordship, and your lordship will kindly see the completion certificate they have issued. It's very clear, your lordship.
Once they say that they have got a committee to look into the matter, whether that committee was correct in holding that yes, they could have looked into the matter, but can they repudiate it now or not?
Lordship.
In the writ court.
Lordship will kindly, one aspect your lordship will kindly note, your lordship, their own authority have issued a completion certificate, your lordship. It was, your lordship, dated 2020. The work, nature of the work, your lordship will kindly come to just for a moment, your lordship.
Mr. Potakur.
Lordship.
And just somewhat time.
Lordship.
Tamsher Ali says.
No,
admitted,
that's there, your
go
lordship.
ahead.
Lordship.
Not admitted, don't touch.
Lordship, that's there, your lordship.
That's a no
But
touch.
only one aspect, your lordship. Can they, your lordship, only after issuing completion certificate and everything, your lordship, after paying me 2/3, just for the one portion of that amount, they came and say that there is, we will dispute
That
it.
is what some other forum has to decide, can they or can they not?
No, your lordship will kindly.
If that be final or that is not final,
No, your.
that has to be decided by someone else, not by
No,
us.
that is there, your lordship. When your lordship dispute is, your lordship dispute for the sake of dispute, can that be a dispute?
No, there was a committee.
No, your lordship, they have not filed anything so far as the committee is concerned, your lordship. Where is the material to show that committee has gone into everything, your lordship?
Yes, sir. If the statements in the affidavit are not supported by records.
Lordship, I can support that document, no issue, Lordship, but on affidavit, it has been stated that for the purpose, a committee was constituted.
Yes.
And a committee gave the report. And on the basis, committee rejected, in fact, after verification of all records, the committee has rejected that the work carried out as claimed by the contractor on the ground, that the work is not verifiable on the ground and the photographs do not suggest completion of the work.
Now, your lordship will kindly see for
And
that, your lordship.
this statement, Lordship, subsequently they filed one reply wherein they have stated that our stand is a false, Lordship. So let them go to the authority, Lordship, who will in fact verify who is correct, Lordship. It's a disputed.
First of all, your lordship, they will have to place that committee's report at least, your lordship, so that I get a chance to, your lordship, even to challenge that, your lordship. Without that being brought to record, your lordship,
That
ultimately,
we are also finding a bit difficult because if the record is not here,
lordship.
how do we?
Now
And,
your,
this.
now your
certificate of
lordship,
Third party monitoring,
lordship.
Yes.
that part where in your affidavit you say that there is no document. The third party giving you a document or not giving a document. Can that be to his detriment if the third party is not maintaining their documents? The file was processed, superior authority that no documentary evidence of supervision carried out from third-party monitoring agency were furnished. Now he has given that certificate that this is a certificate given to me by the third party.
Not in record, that was not found. That is what the committee states, Lordship. In the petition, it has been annexed. Committee can give the certificate to the petitioner also. And if the petitioner fails to submit the documents before the authority, Lordship, this finding will come, Lordship.
Lordship, if your lordship permits, your lordship, your lordship will kindly come to page 31, your lordship, for a moment. 31. The completion certificate issued, your lordship, which says, this is to certify that the work of cleaning, desilting and maintenance of all city drains of Guwahati or so and so, package number so and so, area are completed. First phase. First year maintenance, second year maintenance, third year maintenance by the contractor, so and so, your lordship. Now it is a maintenance of city drains, your lordship. It was completed in the year 2020. Certificate was issued in 2021, your lordship. Now if they, your lordship, in 24, they say that we need to physically verify it. Is it possible, your lordship? It is, your lordship, and your lordship, this document, your lordship, is not only given to us, this is given to them also.
That is what we are saying, Mr. Bhattakur. When this writ petition was instituted,
Lordship.
any admission on their part is tamsharali. That is the whole line of
Lordship,
writ petition of contractors' bills. Now, when they raise a dispute,
Lordship. No, that is what has fallen from your lordship's mouth. Your lordship, I appreciate that, your lordship.
show us that we can ask them that no, whether or not there is a dispute, we decide that there is no dispute and you should pay.
No, your lordship, I will not go to that extent. Your lordship. My only point is, your lordship, when their own authority has admitted, your lordship, they have come up with a plea that this document is not there, which according to me, your lordship.
Exactly. So that has to be decided whether it can be now verified or not, whether they can resign back from the certificate given by their officers or not. These are
They have not resigned it back, your
It's
lordship.
not there.
They have
Saying
not,
we did not
your
receive it.
lordship will kindly see completion certificate which is issued by the executive engineer. They have not taken any action against this. That
Which is the third party certificate.
That is, your lordship, page 32.
The 32, they are saying that it is not available with us.
That is, your lordship, that exactly that has not been said by them in the affidavit. Your lordship will kindly see. And that's why, your
No
lordship,
documentary evidence of supervision.
lordship.
Page 36, Lordship. Last two lines, first paragraph.
That is what I'm reading.
However, it was observed by the superior authority that no documentary evidence of supervision carried out from the third-party monitoring agency were furnished.
Mr. Bhattakur,
Lordship,
we can ask them to produce the supporting
Lord.
documents for the affidavits. We can
Lord.
very easily do that. But I think it would also be prudent if we ask you to have your instructions whether to pursue the matter in the present form before this court, where at the end of the day,
that I will do, your lordship.
and some quietus may be.
Lordship will kindly say that in the meanwhile, even if they produce that report of the committee, your lordship, which goes against me, even if they take certain decision, I am entitled to that, your lordship. This is adverse, that, your lordship, which have a consequence for me.
Yes, Mr. Nair.
If
That-
Lordship directs, then definitely I will place.
If-
Lordship.
if
But
that-
but he can also approach the authority asking for a copy of the same.
What we will say is that he would go for instructions from the petitioner whether to pursue this. And
Lord.
you have your instruction. If you can place on record the dispute part, he would have his options.
Lordship, that's what your,
Whatever way it is.
He is limited to the committee report.
As of now,
As
he
of
says
now.
that if the committee report is not brought before him, the dispute,
The committee.
what we understand,
At
what
the-
we
at the
understand, as-
initiation, Lordship, committee report was never a ground.
never an
for
issue, but
petition.
then if we go by that, then I would hold that this affidavit not being supported by any document and no records being produced, we will not go by the affidavit. It remains an unsupported affidavit. Since you are depending on records, so the affidavit goes, therefore the dispute goes.
Lordship.
The dispute is
That
only
can be
because of
placed,
the
Lordship. I am not objecting if
Ah.
only that committee report. What is the content of the committee report?
That is
already there in the
important,
the
affidavit.
basis of your dispute has to be before this court for us to hold that there is a dispute
It can be placed.
and we cannot adjudicate.
Lordship, it can be placed.
Only an affidavit to that effect may not suffice.
Only that report, not.
But Mr. S. Bottakul and Council the petition. Also heard Mr. P. Nayak, that additional advocate general appearing for the
1, 2, 3, and 4, Lordship. All respondents.
respondent number 1, 2, 3, and 4, all of
All respondents.
Mr. Bottakul has drawn attention of this court to the different documents annexed to the writ petition to show that the certificates of the completion certificates and the certificates of third-party monitoring of the work executed by the petitioner are proof enough of the work having been completed by the petitioner as required of him by the work orders. Therefore, therefore, the respondents are liable to be directed to pay the amount admitted in the contract petitioner. The learned additional advocate general has referred to the affidavit in opposition filed on behalf of the respondents to contend that the superior authority in the department had observed that no documentary evidences of supervision carried out from the third-party monitoring agency were furnished, and further there were no documentary or photographic evidences regarding status review, monitoring, etc., except the completion report. It was further averred to in the affidavit that the GMC had constituted a committee to take decision on matters pertaining to release of huge amount. And after verification of records, the committee had rejected that the work carried out as claimed by the contractor on the ground, that the work is not verifiable on ground and the photographs do not suggest the completion of work. Mr. Bottakul has submitted that the report of the committee has not been produced before this court along with the affidavit in opposition, and therefore he has no notice of what is contained in such a. This court also finds that mere submissions made, the absence of records being placed in support of such submissions may not suffice the contentions of the respondent for the prayer of. As such, the learned additional advocate general, Mr. P. Nayak, the learned additional is accommodated for 2 weeks to have the records based on which the affidavit in opposition has been filed to be placed before this court. Since the respondents attempt to raise a dispute since the respondents are attempting to raise a dispute on the basis of records, Mr. Bottakul and counsel for the petitioner may also have his instructions on the next date. It's this matter again on how much time? What time did I say? 2 weeks. List the matter after.
Few more what, Lord?
Yes.
Instruction regarding.
Huh?
Instruction.
If the dispute is something which is on record, he has to know what to do with the matter. Either we stand here and dismiss it or he makes a prayer for.
Your Lordship said petitioner also take instruction.
I will take
Since you have raised a dispute in the matter, if supported by records, he would have his instructions on this. If it is a matter of dispute, we will not interpret. We cannot pass an order. We cannot pass an understanding. If the dispute is not supported by records, then the affidavit has to.
Deeply.
List the matter again after 2 weeks on a date to be fixed by the date.
Sure.
Yes.
We are
We are representing
Mr. Hendik was required to file an affidavit. Any affidavit filed by the state, Mr. Sharma?
Most probably as because lordship it up to the NHI DCL as because it's a technical thing. So accordingly, the matter is placed before the NHI DCL to take a decision regarding that. That is the instruction lordship we have received.
What is the prayer in the writ petition?
So, minutes, we are representing a burial ground in the Kasipur village.
You are representing a
Burial ground. It's a graveyard.
burial ground.
Yes,
Burial
it's-
ground.
it's a graveyard. Minutes. And we
Uh-huh.
are it is on our land. It has exists since 75 years. And now, so they are constructing, the NHA is constructing a national highway. They are widening the national highway and they included our land as well. So we moved an application before the concerned authority. After they notified and they excluded our land. They recognized our grievance and they excluded our land and they accordingly they issued a notification. Subsequently to that notification, they again issued a notification in which our land again was included. So how come there could be a two notification?
Some
My lord,
respect to the
no,
deceased.
that is, fact is not this way, my lord. My please your lordship. This fact is this, I have received instruction, my lord.
Then perhaps you'll have to file your affidavit.
Yes, that is my submission very beginning. I have received instruction because as per my instruction, already declaration made under provision of section 3B of NHA. And this act also clearly says after publishing of notification under section D, this honorable court may not entertain because these words are like this. Anyhow, I am not that. But there is a lordship is very much aware. There is a various Supreme Court judgment is there. Even Mandir, mosques, we are bound.
Those are belief.
No, that
They
is
are way
where.
of
No,
the
beliefs and the decision, that is I'm telling. Supreme Court judgment, public importance is that. Apart from that, my lord, lordship, I have instruction, as lordship very beginning it is said, I want to bring by decision, by way of affidavit, I'll bring it.
But Mr. You are,
I'm DK Agarwala appearing on behalf of SA Bolbhoia.
you'll have to be a bit slow. You are Mr.
DK Agarwala.
Appearing on behalf of Mr. S.A. Borpian. Good stop. Mr. C. Purva, Learned Standing Council, NHIDCL.
NSIDCL as well as NSI, George is not affected party.
as well
Rather,
as the
I am
NSI.
appearing 1 to 6.
Appearing for the respondent number 1 to 6 has submitted that he has received the instructions
From
the
NHIDCL.
NHIDCL and would like to file an affidavit in opposition to bring on record the stand of the.
Can you fix a date, minutes?
We'll fix a week.
No, fix a date, minutes. Otherwise, our prayer get infectious. Minutes. There is no interim.
Suppose you fix it in the last week of December.
I know your lordship won't do that.
List this matter again. In the first week of December 2025, enabling Mr. C. Burwa to file his affidavit.
On behalf of NHIDCL. On behalf of
On
NHIDCL.
NHIDCL on or before the 21st of November 2025.
21st of November.
2025, and the petitioner would be at liberty to file the affidavit in reply, if any, in the week thereafter.
Obliged.
First week of December.
Much advance.
May it pleases your lordship. Your lordship, this matter is regarding cancellation of the sale permission, which was earlier granted by the office of the deputy commissioner.
My learned instruction is still awaited. I'm seeking some more time.
Lordship,
Where is the sale permission which was granted to you?
sale permission that starts from page number 52.
52.
This was the first one, second one on 53, and 54, 55, 56.
And where is the
57.
cancellation, sir?
Cancellation, we did not get any speaking order. It was only in the website of
Where is it?
NGDRS.
Where is it? That printout somewhere it must be.
It is at page number 68. That is annexure 15. NOC was cancelled.
Heard Mr. So and so learned counsel appearing for the petitioner. You executed some agreement to sale.
We executed agreement for
Then
sale.
you applied for the NOC.
NOC,
The
we obtained
was
the NOC.
Granted.
NOC was granted, then
Then
we
you-
obtained GMDA permission. Then we purchased the stamp duty, requisite stamp duty. Then we went for registration on the NGDRS. This was displayed. And we came to know from the office of the CDC that our NOCs have been cancelled. On the basis of a letter issued by the circle officer after 1 month of grant of NOC that these plots of land require re-verification. So that is the basic fact of the case. Already on 2 dates, they have taken time for seeking instruction. It is like that.
This is what we are finding a little bit surprising. He is without instructions, you are with all of it.
Page 72, my lord, there, my lord, representation is pending.
Wait.
Representation is also there.
Representation is pending.
Pending, my lord. Page
The
70.
case is pending, sir.
Nothing has
It
happened.
can be done in this way also, my lord. It can be disposed of with a direction to give a speaking.
No, if we find that the cancellation is without notice,
Without notice.
then what happens?
Without notice, without rendering us an opportunity
Then
of
what
hearing.
happens? The cancellation goes.
The cancellation.
Cancellation goes, he has a breathing space of 1 week to carry out whatever he wants to.
Lordship.
Yes. Within a very short time, I'll get it.
For cancelling anything,
That's true.
something has to be
Yes,
done
yes,
prior to that.
Yes, yes.
But Mr. So-and-so learned counsel appearing for the petitioner who has submitted that after the petitioners had been granted an NOC to carry out a sale of the land in their possession, comma, when they went to register the sale deeds, comma, they were informed that the NOC issued to them earlier had been cancelled. The website showing the cancellation of the NOC did not reflect any reasons. And it is the case of the petitioners that they have already purchased the stamp duty and other requisite formalities have all been complied with. And the sale remained unregistered only on the basis of this cancellation. In such circumstances, the petitioners have approached this court by this writ petition. Notice in this case was issued on the 18th of August 2025. And on 2 occasions, time has been sought for by the respondents to have instructions. Today, when the matter is called upon, the learned counsel for the respondent makes a submission that he is yet awaiting instructions. List this matter again after 3 weeks on a date to be fixed by the registry to enable the state respondents to place before this court their stand in the way of an affidavit to be filed during that period, comma, failing which the concerned authorities, the authorities who were concerned with the cancellation of the deed shall remain present before this court to explain the reasons why instructions in the matter have not been supplied, despite notices having been issued and received on their behalf, and the matter on their behalf. List as a person. List.
Lordship, if possible, it is.
Since the lordship has made a direction, my lord, to file the affidavit within 3 weeks, failing which the concerned authorities cancelling the sale permission help to be present.
What did you say that sentence? Can you read it out? List this matter after 3 weeks, by which time? Yes. What did we say? Just say that. List this matter after 3 weeks. On affidavit. failing which uh, 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 failing which the authorities concerned failing which the authorities concerned with the cancellation of the NOC shall remain present before this court to explain.
So my lord, I'm praying for a particular date.
Lordship,
particular
particular date may be fixed. Can it be?
If I fail, my lord, they'll have to be present. If they fail, not I.
List this matter again on the 3rd of no, 3rd of December 2002.
Can it be in the month of November, last week?
How would have this third?
Deeply obliged.
In this case, what is happened, my lord, actually petitioner was, my lord, elected for the post of government side, my lord. But on the ground of, my lord, on wrong view, my lord, taken by the inquiry committee, that I have more than 2, my lord, children, my lord. I have been disqualified, my
You
lord.
don't have more than 2 children.
I have 2 children, my lord, but third side, one added, my lord, here is my brother's, my lord, daughter.
How many children do you have?
I have 2, my lord.
2.
2, my
The
lord.
third child they have added upon you.
Added, my lord. Third child, my added brothers, my lord.
Child has been shown to be
Yes,
your
daughter
child.
added. It is. I have also annexed the, my lord, the birth certificate also.
Ah.
That is brother's, my sister-in-law's name and my lord brother's name is reflected. And in the affidavit in opposition, they have filed, my lord. This specifically mentioned that Jennifer Akhtara was alive. But that is, my lord, my brothers. I have also brought the original papers also. It is seen that, my lord.
They have filed an affidavit. Have you
Affidavit.
received it?
I have
you
received it.
received the affidavit?
I have also already annexed here, my lord, birth certificate also, my lord. My brothers, my lord, daughters, everything.
Private respondents, sir. Yes. I am appearing.
And they have, my lord, unsuccessful candidates, my lord, husband.
Please.
Private respondent.
Who has disqualified it?
It's the state authorities.
What has the private respondent got to do
Complainant,
with
my
it? Nothing doing. You tell us. He gave you the papers. He gave you a complaint.
Yes.
You made an inquiry.
Yes.
Defend your inquiry.
Yes, ma'am. Page, para 66.
Of what?
Page 66. Our affidavit.
Yes. 66. What does it say?
That with regard to the statements, para 6, ma'am. That with regard to the statements made in the paragraph 6 and 7, the writ petition, the deponent respectfully stated that one application dated 5/6/2025 submitted by the petitioner alleging that a complaint lodged by the respondent number 8 was false and fabricated. In this regard, a statement of Alaya Khatun, Anganwadi worker of the Nathongua AWC was recorded, and as per her statement, she confirmed that the petitioner has 3 living children and they have been provided taking home rations as well as uniform from the Anganwadi center.
Penalize him for taking more than what he deserved. But can you implant a child into his family?
The below one.
Yes.
Paragraph 5.
Moreover, my lord, the inquiry report of the executive magistrate concerned as referred in the paragraph 5 also stated that the petitioner has concealed the third side and submitted false affidavit before the concerned authority. Officer doing the submission is of the nomination.
Where is that record? Where is that report of the executive magistrate? Is it there with the writ petition?
It has not been annexed with our affidavit. But
Then he has
an
done the
inquiry report of the executive magistrate.
Where is it?
It has not been with the record.
Paragraph 5, your lordship, read it.
Paragraph
5, my lord.
Jennifer Akhtara was alive.
Yes. Jennifer Akhtara is my brother's daughter.
When was she born?
I am Jasmina. Sahida is my sister-in-law.
She was born on 2012-2022. Name of the mother is Shahida Khatun.
Yes. Petitioner is Jasmina.
And the child named Jennifer Akhtara was alive in the
Unnecessarily, my lord, she has been stopped, my lord. without hearing me, my lord.
Who is Billal?
Lordship, Billal is brother-in-law.
Huh?
Brother-in-law.
Brother.
Yes, my lord.
Yes. Yes.
Yes, 47. 47. 47.
What are your records to show that he has 3 children?
Jasmine is repeating.
Yes, conferencing over.
No, I have given him this one.
Conferencing over.
One second,
Please address the court.
one second.
Oh.
I'm going to the annexation.
Go ahead. We can have a round table there for everybody to sit and confer in the court.
No.
Huh?
So, it's the Jennifer.
A man is saying that
Yes,
child is not my daughter.
Yes.
Some Anganwadi worker is saying somewhere, no, he's taking ration. That is his daughter. So now you implant children into people's home.
Can I put down my inquiry report? Report is on the report.
She is being denied her constitutional rights.
Yes.
She has been elected to a post. Yes, private respondent. Who is it? Huh? Please come. You were there.
Husband of a defeated candidate.
Okay. So how do you say that that child is his daughter from where? Can you show us anything? An item number
17.
17.
Annex 3, page 29 is the
Now,
complaint.
if we
petition.
say it is his daughter, Mr. Das would not like it. Mr. Das's client's daughter. From where are you saying that?
Lordship, I'll submit the additional affidavit.
Till that time, we allow her to function. You will file an additional affidavit.
Yes.
Where is the first affidavit for an additional affidavit? There must be first an affidavit, then you will have an additional affidavit. Where is the first affidavit you have filed? Where is the complaint, Mr. Das? Where is the complaint?
Page, my lord, 29, Annex 3. (31) is the particular.
That executive magistrate's inquiry, did you participate in it?
No. Did
You were not asked anything.
Not asked, my lord. Individually, she has submitted report. That's why we filed an occasion also repetition, my lord. In the repetition earlier occasion, my lord, that order has been specifically passed by this honorable court, my lord, that you give this chance. But subsequently, then also, my lord, they have.
Where is
confirmed
the earlier repetition?
earlier order?
Yes.
Yes, my lord. I have annexed here, my lord, that is page, my lord, starts from 54.
54.
Yes, my lord.
Yes.
Annex 16 and relevant portion.
Same case, same petition.
Yes, my lord. 56 relevant, my lord. Finding 62.
If a court also does not tell you with a complaint or. Therefore, court also does not tell you with the complaint page 29 with the birth certificate page 47.
The complaint.
Complaint, my lord, it says that Sri Ranga was born on 22/8/2021. And in the mother date of birth, it is 20/12/2020.
And according to you, date of birth is of 28/1.
According to the complaint, respondent A, it was 22/8/2021. And the death certificate shows 20/12/2020. This one. So,
You are a member. You are
Yes.
elected member.
Yes, my lord, elected member. Highest court I had.
Have you seen page 62? Yes. Page 62, last paragraph, please read. Where is the inquiry report dated 31/5, sir? Mr. Das, where is 31/5?
31.
Please read the last.
Page 32. Relevant person 33. Local vernacular next.
Your prayer clause says this order was passed on 23/7. This order that you have shown us at page 55.
Yes.
It was passed. Yes, sir. Did you read that last paragraph?
Yes.
What does it say?
it says
You
by-
cannot stop her from participating or being a member.
Yes, doing the mandate.
Then,
Uh,
if she has not been disqualified. Yes, Mr. Das. In this prayer clause, you have asked for setting aside of 19/5, 31/5, 16/7, and 19/7.
Yes, my lord.
And your order in page 55 was passed on 23/7.
Now, my lord, impugn order is, my lord, one provision and order, my lord.
Where?
Page, my lord, that is kindly peruse your lordship, page 48, annex 13.
What is the page?
Impugn order.
What is the page?
This one is the first impugn
Just
order.
tell us the date.
Yes, my lord, 16/7/25.
Exactly what I'm telling you.
Yes,
The writ
disqualified.
petition- The writ petition, which was disposed of on an earlier date at page 54. It was disposed of on 23/7.
Yes, my lord.
You did not bring it to the notice of the court.
My lord, I have received subsequently. I have mentioned here.
Where?
After filing the case, I have received this copy. Earlier filed, my lord.
When did you receive it?
Yes, my lord. I have stated, my lord, that is, my lord, is annexure 13. Yes, my lord. Paragraph 11, page 12. That your petition begs to state that page 12, paragraph 11.
Page 12.
Subsequently provided. That your petitioner most respectfully begs to state that in spite of all those efforts, the District Commissioner Goalpara by fiat order dated 16/7 disqualified your petitioner from the post of the member of the GP under section so and so, followed by the rule so and so. But copy of the same has not been served upon her. Your petitioner could come to know about said disqualification by a letter of the authorized officer, Joleswar Development Block on 18/7/25, whereby first meeting of the said GP meeting was convened for the fourth time held on 19/7, and the elected members, except your petitioner, were directed to be present in the said meeting. It was a letter, 18/7, 16/7/25, Annexure 13.
Disqualification order is on 16/7. Where is it?
Yes.
Where is it?
This 48. Thereafter it is rectified, this order. Page 52, Annexure 15. Middle portion. GD relevant section under which Srimati Jasmina Khatun Gao Panchayat member of so-and-so Takimari so-and-so Gao Panchayat has been removed may be read as under section 112A of the Assam Panchayat Amendment Act 2008.
Yes, where is that notice given to her prior to passing of order dated 16/7/2025? Where is your statement saying that yes, there is a notice?
That is not.
It is not there. So she never had a chance to participate before the Nikhamani. Huh?
Never.
When can you have the records of the inquiry, sir?
2 weeks, man.
Huh?
2 weeks.
List this matter again on the 4th of December 2025.
In the meantime, she may be allowed to function. Others, admittedly, all papers shows that it is.
What is stopping you?
Lordship?
That disqualification is stopping you. That order is stopping you from
Yes, my lord.
participating.
This way,
Yes.
my lord.
We allow that interim order. What do we do? Allow the final order. We'll be
No,
granting you the final relief when we are granting you
Yes,
the
yes.
interim relief. Can I do that?
No, no.
No. So, allowing Mr. So-and-so Learned Counsel appearing for by the way, dispose korilu case to insurance. Oh, no, it medical okay. What did you say? 4th of December 2025, allowing Mr. Endas Learned State Council to apprise this court to place before this court the records on the basis of which the order dated 16/7/2025 and 19/7/2025.
Yes, 19/7.
Annexed as Annexure 13 and
15.
Annexure
15.
18.
15.
Annexure 15 to the writ petition had been passed by the District Commissioner Gwalpara. Stop. This matter relates to disqualification of an elected member of a Gaon Panchayat, and therefore the respondents shall ensure that the relevant records are placed before the court on the next date of listing without fail. 4th of December. The respondent number 8 in the meantime may file the reason, the affidavit in response to the writ petition before the next date of listing. To bring this by.
Yes.
And if you have just lodged a complaint without any basis for causing a delay in the constitutional working, complainant may not be a happy man on default. No. Bring forth your reasons why you made the complaint, on the basis of what. You have stopped the constitutional process. Yes. Next.
Obligation.
May it please your lordship, my lord. My lord, actually here, my lord, I am the auction purchaser of a particular plot of land from the central bank, my lord. The page 23 is the certificate, sale certificate. My lord, on 27/9/2014, this land measuring 2 katha 15 lesa was. But however, there was some litigation. These are all ended. And I made the representation, my lord, even the suit file also rejected on the ground that no cause of action. And my lord, this representation I filed, Annex 10, page 59. After completion of all the.
With what the Supreme Court has said recently, would you
Your
not be
lordship,
bound to sell it to him?
Yeah.
Are you not bound to sell it to him now? To
Yes,
give
your
him
lordship.
possession
We have-
after?
No, no, your lordship, we have issued them the sale certificate
Ah,
and we have handed over the possession to them. And they have accepted in the year of 2014. But thereafter, some high court writ petition is pending, and thereafter title suit is pending, thereafter CRP is pending. So a long period has already been elapsed, your lordship.
No.
Did
All part and parcel of the property has been handed over to him?
Yes, your lordship. all
Entire land
2000
is in his possession now?
No, no, your lordship, but they are claiming they are not in a possession, your lordship. Now, we have also, the land is a vacant land, your lordship. There is nothing has been constructed, no person is there, your lordship. So your lordship, I just seek 1 week time or 2-3 days time may be given. I'll just bring out all on record, your lordship.
You were given that time in August
Your
2005.
lordship, No, I have just forget, your lordship. Just humbly submitting that, your lordship, that after that Durga Puja and.
Mr. Sharma, Learned Counsel, appearing for the Central Bank of India has submitted that due to inadvertence.
Yes.
He could not place the
instruction.
developments which took place as required by the order dated 27/8/2025. This court grants another 2 weeks time to the council for
I'll-
respondents to bring on record the relevant developments
As to why the possession of the land could not be given.
as required in the order dated 27/8/2025. Full stop, list the matter again in the first week of December 2025 on a date fixed by the registry, by which date the learned counsel for the respondent shall ensure that the latest developments are brought on record either by way of an instruction or by way of an affidavit. Stop. Yes.
Also, I can pray this one thing that your
Yes.
lordship, this matter may be come up on 1, 3 or 4, your lordship people.
Yes, my lord. My
On
lord,
the
may we
second
please-
of, on the 2nd of December.
Your
Ma'am,
lordship,
obliged.
second is, I think, holiday, your lordship. No holiday.
No, no, no. It's okay.
2nd of December?
Yes.
Yes, your lord.
Obliged.
But you bring the developments,
Yes.
give him the land.
Your lordship,
Just
it is
close
not
this.
possible, I think, because we have heard that some sale deed has been executed. That is why I am delaying, your lordship.
This is their fault.
Between
This
whom?
land.
Between the borrower and the third party, your lordship.
How is he concerned? You give him the land.
That is
You owe
why I
him
am
the land.
seeking 1 week time, your lordship.
Obliged.
Lordship, here in item number 18, Lordship, here we are only now waiting for the documents that we had, original papers that we had mortgaged initially to be returned by the bank, Lordship.
Why don't you return it?
Lordship, I am for the private respondent number 4.
For respondent number
Who
3,
is he?
Lordship,
Number 4, what is he?
he is one of the directors, Lordship. There were 5 directors. 4 of them are in front of your Lordship. Respondent number 4 is the 5th director. He is the one who has fraudulently
Fraudulently.
Lordship, yes, he has been acting without the consent of the other board members. He has repaid the loan and now he's asking for the documents.
So who has to appear? The
Punjab National Bank, Lordship, here
who
respondent.
appears? Punjab National Bank Standing Council. I don't remember even the someone appeared before.
Yes, Lordship,
Who?
Mr. The cause list is showing Mr. Ganguly, Lordship.
Mr. Scroll টা দিও, maybe his junior will notice. Last attempt. Last attempt. 19.
Yes. May allow me to take fresh steps upon respondent number 5, Lordship. Respondent number 5 steps has not been completed.
The dispute in this petition appears to be a private dispute. Why the steps? From 16.
Yes.
What is the dispute? Not with what has been noted. Bill loan landowner and bill. What is your prayer? It's who appears for the police authorities? Yes. He has made a complaint. You have not registered it. Why?
Already raised that, my lord.
Raised that?
Yes, my lord.
Prayer granted.
No, my lord, in 16 we have filed affidavit and investigation is going on at that.
Page 10.
Is there.
Please come to page 10 of the petition. What is the prayer?
Investigation case has been registered, my lord, already.
Now, now to register a case with regard to 16-116 and 9-3-16.
Yes.
There were two documents.
Yes.
Please have your instructions. We are here for the next 5-10 minutes. Find out from the police station if the FIR has been registered.
Yes, already registered, my lord. We have already filed affidavit.
Yes. Your prayer is to register a case. They have registered it.
Give me some time to take instruction.
Ask your parties. We are doing it today.
Lordship, we are unable to contact the.
Then we close it. Far
We
better.
can take it up tomorrow. Lordship.
Huh?
Tomorrow.
Supplementary or not? Just have that instruction. If the FIR has been registered, no use pressing this 2016 on the prayer of the United Council for the petitioner. Place this matter again tomorrow to enable him to obtain an instruction as to whether the relief paid for in the writ petition, that is registration of an FIR on the basis of his complaint, has already been complied with by the respondents. Mr. So-and-so appearing for the respondents has submitted that the FIR has been registered and investigation has been
Was continuing at that time.
was continuing as on the date of filing of the affidavit in opposition. Please find out whether it has been completed. Have that instruction from the
Yes, madam. In that case, my lord, some more time.
tomorrow. If he can get it without a contact to his petitioners tomorrow, the running police station, you can do it tomorrow. Okay. Hi.
In this matter, my lords, I appear for the respondent bank.
Ah.
And my lord, the petitioner has made certain payments. My lord, there is no possibility for the next 4 weeks or so of classifying the account as NPA.
Ah.
That was the grievance of the petitioner, my lord. So at this stage, my lord, perhaps my lord, we will file a reply. That may be taken up after 4 weeks.
The revision even after filing the execution. Two prospective buyers who agreed to say of November. Over the month 30th of November, however, respondent reflected the repetition. Now he is saying that he is not taking any action for the next 4 weeks. They are not declaring it to be an NPA.
Yes.
Maybe you'll have the sale by that time.
I'm sorry.
Maybe the sale will be completed by that time.
Of course.
So
Yes, yes, of course.
should we say on a consensus, we have this matter
Yes,
listed on the
correct,
second week of
correct,
November?
correct.
Heard Mr. D. Das Nanak, Senior Counsel, assisted by Mr. S. Ladak Counsel, appearing for the writ petitioner. Mr. So-and-so appears for the respondent number 4.
All respondents.
Respondent, huh?
There are only 2 respondents.
Bank. For the respondent bank.
Yes.
Stop. On a.
There are 2 respondents.
On a joint submission made by the parties, list this matter again in the second week of December 2025, since it is submitted that by that time there is a possibility of some conclusion being brought to the matter. We'll just say second week of December.
Interim.
There is an interim order.
The interim order passed earlier. Chapter 3.
Yes. I'm deeply obliged.
Yes. Is Mr. Ganguly?
Lordship, here he is one of the panel advocates who have been informed for Punjab.
In fact, Milord, at one point of time, I was appearing the matter, Milord, but as a standing counsel. Now there are other standing counsel.
No, see, what he's saying is that everything else has been done.
Yes.
Only the mortgage papers are to be returned to him.
Title deeds are to be
The
returned.
title deeds
Yes,
are to be returned to him. Otherwise, the writ petition is otherwise over.
Look, the petitioner can give me one copy, Milord. I'll take inspection and the next date, Milord, perhaps.
That can be done.
We will have it again on the second week of December.
Lordship may have.
Mr. A. Chaliha, learned counsel appearing for the petitioner, has agreed to supply a copy of the writ petition to Mr. So-and-so, who usually appears for the bank, respondent bank, full stop. Mr. So-and-so has agreed to pass on a copy of the writ petition to the bank and have his instructions on the submission of Mr. Choliha that it is only the title deed of the title deeds of the property involved that are required to be returned by the bank, and the matter can be given a quietus. Full stop. It is noticed that the writ petition relates to the year 2014. Therefore, an attempt would be made to dispose of the writ petition in case the bank authorities agree to return the title deeds to the petitioner if other conditions for such return has been complied. List again on the second week of December on a date to be fixed by the registry. Thank you.